The U.S. Supreme Court is looking at a case that will decide whether landlords will be forced to take Section 8 vouchers from disabled tenants. I'm Tony. And this is Real Estate Investing and Landlord News. All right, so I have an interesting article for you today, and it's going over this case that is being presented to the Supreme Court. Now, this case has to do with Section 8 vouchers and whether landlords should be forced to accept them or not, okay? And it's really an interesting question. It could have implications on, just basically all landlords throughout the entire country, especially since this is a Supreme Court case, okay? So, yeah, this is a thing where they're talking about tenant who is disabled who receives a Section 8 voucher and whether the landlord has to accept that voucher, has to participate in the program, even though the program is supposed to be voluntary. Now, they talk about how this has to do with landlords making reasonable accommodations for people with disabilities because the person who receives this voucher, they actually are disabled and they're unable to work, and they receive the voucher in order to pay their rent because they're unable to increase their income any other way. They wouldn't be able to pay the rent. And it's an interesting way to look at it, and it sounds like a bad deal to me because it's a slippery slope. It's a slippery slope where basically the Supreme Court is saying that, hey, people who don't want to participate in this voluntary program, they have to participate. They have to jump through the hoops. They have to get their units inspected. They have to deal with the housing authority that they don't want to deal with just because we have these tenants over here, and that's not what the kind of thing that we want to be hearing about. Okay, the property owners should have the overall say whether they want to participate in this program. Now, I do understand that the law says that, hey, we have to make reasonable accommodations for those people who have disabilities, right? But I don't believe that accepting a Section 8 voucher is a reasonable accommodation for a disability. A reasonable accommodation for a disability is like accepting somebody who has a blind person who has a seeing eye dog when you don't normally accept pets, or putting in a ramp for a person who uses a wheelchair. Those are reasonable accommodations. Being forced to participate in the Section 8 program, I don't think that's a reasonable accommodation. That's unreasonable in my opinion. So before I get into the article, go ahead, hit the like, subscribe button, maybe leave a comment down below. Let me know what you think. So do you think that landlords should be forced to participate in the Section 8 program for tenants with disabilities? Okay, people who are receiving their income, receiving the Section 8 voucher because they are disabled and unable to work. Do you think landlords should have to participate in that program? Now, keep in mind, I'm a Section 8 landlord. Okay, I have Section 8 tenants. I do not enjoy participating in the program. One of my tenants who's a Section 8, or I'm sorry, all of my tenants who are Section 8 are inherited tenants, okay? But I've had no issues with them. They haven't given me any problems yet. But the hoops that I have to jump through to continue to participate in the program, continued inspections, making unnecessary repairs, in my opinion, it's a burden. I understand why there are some people who don't want to deal with it. Plus, there are plenty of landlords who have nightmare stories about awful tenants that just they don't want to even participate in that program anymore. So anyway, let's get into this article. It kind of goes over more details specifically about this case. This article is coming from SCOTUS blog, and it says Section 8 vouchers take center stage in dispute between landlord and a disabled tenant. Yeah, and they go over a lot of the details here. So, I'll put my commentary in, as we go through it. But let's get into it. Federal law bars housing discrimination against a person with a disability. Under the Fair Housing Act, landlords and sellers must provide reasonable accommodations to give someone with a disability equal opportunity to rent or buy a home. This week, we highlight the petitions that ask the court to consider, among other things, whether the FHA requires landlords to accept so-called Section 8 vouchers from tenants who are too disabled to work. Sue Ellen Klossner is a resident of Table Mound Mobile Home Park in Dubuque, Iowa. She suffers from physical and psychiatric disabilities and receives her sole income in the form of benefits from the government. In 2017, the park was purchased by IADU Table Mound MHP, a subsidiary of one of the largest mobile home park owners in the country. Over the next 2 years, IADU consistently hiked the monthly rent that Klossner paid for her lot in the park. It also began charging Table Mound residents separately for utilities such as water, sewer, and trash collection, so that by 2019, Klossner's rent and utilities were more than half of her monthly income. And, I feel for the lady. She's on a very fixed income. She's disabled and unable to increase her income according to this, right? So, yeah, she has to base all of her bills on that little amount of money that she's getting from disability or from whatever government benefits that she receives. So the thing is, though, that a lot of these mobile home parks, right, they are owned by small mom and pop operators, right, and the rents in them are far, far below what the market rents would be. So you see in the case here, they talked about a larger mobile home park operator went in there, they bought this, right? And the previous owners were paying all the utilities. The utilities were included in the rent. The rents probably were way, way below market. And so you can't blame the owner for coming in there, buying this property, and then bringing the rents up to the market rate, and then charging the tenants for their own utilities. You have to pay your own utilities, like that's one of the very first things that a lot of landlords do when they buy a property. If the former landlord was paying the utilities, well, they push that back onto the tenants so that they can increase the amount of money that they're making, and the bills that they're paying out are much, much lower. I mean, it's a good strategy. It's a strategy that most landlords are using. And the fact that she had such cheap rent for such a long period of time, it was just lucky. It was just lucky that her former landlords were not operating their business efficiently. Okay. But yay, the new landlords, they got to change things up, right? And that isn't even a question here in this whole argument, right? But because they increased these costs, that's why she applied for Section 8. So let me continue. Due to rising costs, Klossner applied for and began receiving housing choice vouchers from a program funded by the Department of Housing and Urban Development and administered by local authorities that provides rental assistance for low income tenants. Participants in the program, known as Section 8, pay 30% of their income toward rent and utilities. The local housing authority pays the rest directly to the landlord. In Iowa, landlords are not required to accept Section 8 vouchers. When Klossner sought to use them to pay her rent, IADU refused on the ground that accepting vouchers from Table Mound residents would create an administrative burden. And, I'm pretty sure what they're talking about is they are going to it would open a can of worms. If they accept Section 8 from this tenant, right, then they have to accept Section 8 from all of the tenants. And that's something that they just don't want to do. Okay. And yes, there is an administrative cost to it. Fortunately, it's not going to be terrible, but I don't know exactly what the Section 8 requirements are going to be for a mobile home park. That's something I haven't heard of before, where the tenant actually owns the trailer or the mobile home that is sitting in the park, and the landlord owns the land. That's kind of a different form of or I'm not 100% sure that's the case in this situation, but they kind of made it sound like that's what it was, because it said up above that she well, you know what? It doesn't say here specifically that she owned the mobile home that she's living in, right? So I guess we can assume that it is a rental unit, kind of similar to just a regular apartment unit, if that's the case, right? And that the mobile home park owners actually own the mobile home she lives in as well. Because I'm not exactly sure how uh, Section 8 can pay land rent, and then if there's an inspection, like, what is the landlord supposed to do? Like, you go into the home that she owns, if she didn't maintain it correctly, does the landlord have to fix it? Like, those are that, like, that doesn't make much sense. But for now, not knowing the full context of the story, I'm going to have to just assume that the mobile home park actually owns the mobile home and the land as well. Okay. And that this is, we can just look at this similarly to just a large multifamily property. Klossner then asked IADU to accept her vouchers as a reasonable accommodation under the FHA, explaining that she cannot work because of her disabilities. Klossner argued that she is unable to earn additional income to pay her housing bills and thus needs Section 8 vouchers to have equal opportunity to live in Table Mound. When IADU denied that request as well, Klossner went to federal court arguing that IADU's refusal to accept her Section 8 vouchers violated the FHA by discriminating against her due to a disability. A federal district court in Iowa agreed that IADU had violated the FHA and ordered IADU to begin accepting her housing vouchers. The U.S. Court of Appeals for the Eighth Circuit reversed. The appeals court reasoned that the FHA only requires landlords to accommodate the physical effects of a disability. For example, an exception to a no pets policy for a blind person who needs a service dog. The law does not, the Eighth Circuit held, compel landlords to make reasonable accommodations for the economic effects of a disability, as in Klossner's case. So, yeah, basically, the Eighth Circuit Court of Appeals has already made a decision on this case saying that, hey, the landlord does not have to accept this voucher because you can't afford your rent due to your disability. Okay. And I agree with that Eighth Circuit decision, but like I said before, this is going to go up to the Supreme Court. The Supreme Court is going to make this decision overall, and it could have implications for landlords throughout the entire country where, hey, now all of a sudden landlords who did not previously want to accept Section 8 are forced to accept Section 8. So, yeah, interesting story. I'll put a link to the article down in the description. I mean, we'll just have to see how this plays out. I'll cover the story again if there's an update anytime soon.